Hi, I'm Anthony Alder from Alder IP, and welcome to another episode in the IP series. Today we're going to be talking about patents, but particularly patents that are held by people that have passed away. Now, this is particularly important is that sometimes inventors pass away and don't leave a will. If they don't leave a will, it is particularly hard to manage a patent going forward because we don't have any idea what the intention of the inventor was when he passed away. Even when they do leave a will, it is very complicated. And part of the reason is because the estate has to make judgment calls about the management of the patents and also has to probably pay money to keep the patents alive, such as renewal fees or handle patent prosecution matters. It's also very difficult to negotiate the licenses and that sort of thing when the person who negotiated the license in the first place has passed away and the estate is now taking over those licenses. And the problem relies in the fact that sometimes the estate has a different kind of point of view to the inventor who originally invented the idea. Sometimes this works and sometimes this doesn't work. It's probably important if you are drafting a will and you do have if you are an inventor, that you put some instructions in there about what's to happen with the patents or what's to happen with your invention or what your intention is, as it's really helpful for people who are looking after your matter in the future. The other big problem is we do run into issues, particularly where you go, where a patent's gone provisional, PCT, and then we've followed a national phase in the USA. Now, if we file a national phase application in the USA, at the time of filing that application, we need to actually file a signed declaration from the inventor about what he knows and also who he is actually assigning, or he or she is assigning that property to. That's no simple task if you're not around anymore. So you also probably want to think about, well, how do I tell people that I have an intention to do that, and also what knowledge do I know about it? And that could also go into a will. You can also write it down in an email or just tell your attorney when you're dealing with it. Alder IP has dealt with some unusual cases in the past. We actually had one case where an inventor filed a provisional application, and 1 week after he filed the provisional application, he passed away. He was actually talking to a licensee, and the licensee was very, very keen to go ahead with the license and very keen to commercialise the technology. We then had to negotiate with the inventor's estate, his widow, and also the new licensee to try and get the whole thing to work. And we actually mediated a license between the parties that everyone was quite happy with, and that the new licensee was quite happy to pay the estate, and the estate would pass that on. And that technology was actually successfully commercialised. And in those circumstances, we were very lucky about the input that we got from the licensee, because he was very helpful in that regard. In some cases, if you don't have a clear intention of the inventor, it makes it very difficult to work out what not only I'm supposed to do, but also what the estate's supposed to do. And we're trying to work out what the intentions are. I hope this has been really helpful. If you need any other information about this topic, please feel free to contact myself or any of the team at Alder IP. We're more than happy to help you. And thanks for listening.